Hi, I'm Ken Mann with Equity Partners HG. Today I'm here with Leyza Blanco, a shareholder at Gray Robinson in Miami. Leyza frequently represents secured creditors and receivers in complex bankruptcy cases. And we're going to talk a little bit today about some of the current issues and key factors in professionals being successful in their representation of secured creditors. So thanks for being here today.
Thank you.
Let's talk about a few of the things that I've heard a lot about in the last few weeks. One being what I've heard is called a cram up. I think everybody's familiar with cram down. Can you tell me what the difference between a cram up and a cram down are?
I think cram up is just a hipster way of referring to cram down upon a secured creditor, which is ordinarily under the priorities a secured creditor that's above the rest of the other creditors. So it's a nifty term for cramming them up, meaning doing what they don't want you to do to them.
As interest rates go up, and they've gone up a little bit, but as they continue to go up, it would seem that debtors and borrowers are going to be motivated to pursue that cram up as a way to keep what maybe is a below market interest rate. Is that a common use of the cram up?
Yes, actually this environment is one in which people who represent secured creditors or secured creditors themselves need to be aware of the possibility that someone's going to want to keep favorable either interest rates or loan terms in their loan documents, and that as a result in a bankruptcy proceeding they might be more inclined to seek to cram them up over an objection versus, say, doing what ordinarily we see, which is either refinancing or paying off the debt. So loan provisions that have below market interest rates are really ideal for a cram up situation.
I've heard you speak of a make whole provision. Is that essentially the same to a bond as a prepayment penalty would be to a typical secured creditor asset-based lender?
So similar to a prepayment provision in a loan document where the lender inserts a provision to make sure that if they are paid early, that they get the benefit of their bargain. So you can see in these developing cases that deal with the make whole provisions, which have made recent headlines, and they are about lots of dollars, and so that's a result of the market, but you can see a potential for them being applied in much less highlighted cases, but equally as applicable.
In a mid-market case, say, where you have an ABL or any type of secured creditor that has a prepayment penalty built into their loan documents, which is fairly customary, I think, but how are bankruptcy courts viewing those agreements?
Well, it's the conflict comes in with the reading of acceleration provisions together with those prepayment penalties. And at least in the more recent Third Circuit opinion, the court ruled that the make whole provision in that scenario was a valid and enforceable make whole provision, despite the fact that the debtor coming into bankruptcy had actually publicly announced that they believed they were able to refinance their debt out after the filing of a bankruptcy, and repaying the debt without making the make whole provision payment.
Okay.
So the courts are, in at least in that particular instance, did enforce the prepayment provision and did require the payment ultimately. But that went up several different layers of appeals, and it really related to a huge sum of money. It was a $431 million price tag on the provision. So I think in terms of reviewing that law and looking at a potential mid-market scenario, lenders have to be aware of exactly what the potential is for the enforcement or not of the prepayment provisions in their loan documents if there is a bankruptcy filing. And I think that's something that, in the developing law, particularly where you have laws that are in conflict. I think in the current situation, the two leading cases are one out of New York and one out of Delaware's Third Circuit, and they're both decided under New York law, but the outcomes are different.
Interesting. $431 million will get people's attention now.
And most certainly will, and obviously there's enough to fight about to get to 3 layers of appeals.
Right.
But in not many cases do you have, in a mid-market scenario where there's that much money to fight over that'll get you that far.
Sure. So similarly, tell me about pre-petition stay relief waivers.
So that's another area where enforcement or not is something that's really factually driven, and also depends upon where you are and your presiding court. Historically, as a lender's lawyer, and particularly in a forbearance or out-of-court restructuring scenario, you generally tell your secured creditor client, don't expect enforcement of these provisions, but more and more over the years, depending on the factual circumstances, you find that courts are starting to enforce the benefit of those bargains. And so the more likely fact scenarios or facts that might support a judge concluding, yes, we're going to enforce a pre-petition stay relief waiver are in, for example, multiple forbearance agreements, additional time, additional access to capital, basically moving away from restrictive loan covenants. When a lender makes those kinds of concessions over and over, a factual circumstance might arise where you could see a court saying, I'm going to enforce your pre-petition stay relief waiver because you've earned it.
Is the argument from the borrower side that essentially you're asking them to waive their right to due process? What is the other side of the argument?
In a pre-petition stay relief waiver, you can file the bankruptcy. You're just not going to get, if the reason you're filing is your lender is defaulted you, or you're in arrears on your loan, it's not going to prevent your lender from exercising its rights during the course of the bankruptcy. So the due process issue is not one that's really successful for borrowers, because they can still go in. It's just not going to be as effective as they might otherwise need it to be in order to be successful.
So even in a scenario where a secured creditor doesn't necessarily want to aggressively pursue its remedies, do you think it's important that they document the file by sending a default letter and taking the steps to preserve their rights? My
advice is consistently know your documents well and call your defaults if you have defaults, and you can always waive them later. You can always negotiate in a forbearance and create potentially the record for having an enforcement of a pre-petition stay relief waiver later. But keeping to the loan documents and making sure that you haven't waived those rights is a fairly interesting and effective tool for lenders who are trying to enforce their remedies later on.
Tell me what's going on in the insolvency world with respect to recovery of fees and interest for a secured creditor.
That's always near and dear to every secured creditor's heart. Obviously, there is a right written into the code relating to the right to recover fees if you are an oversecured creditor. So in an environment where you have collateral, if real estate collateral as an example is increasing in value, you're more likely to be able to recover those fees. Oftentimes loan provisions require that they be reasonable, so the court has to determine the amount. But if you have the entitlement in your loan documents to attorney's fees, and you have the situation in a bankruptcy where you have collateral that's worth more than what you're owed, and you're owed less than what ultimately is recovered, you can get your fees as well, which is important.
Okay, well, thank you for sharing your wisdom and expertise. We
Thank you.
appreciate you doing this.